to promulgate such standards without any prior input from a single stakeholder in those impacted industries. When the ultimate proposal came out on March 27th of this year, it was virtually identical to what the NGO had predicted in 2008 and barred the construction of new coal-fired facilities in the United States. Because of the unique nature of NSPS proposals, the rule is already in effect, even though EPA has yet to respond to a single stakeholder comment from industry on the issue. Thus, as a result of this settlement, we now have an effective rule that is barring new facilities without first offering transparency to the industry impacted, allowing for public participation before the rule took effect, and providing no real means of judicial review at this time. Finally, Mr. Chairman, just to emphasize a point, I do strongly support and encourage efforts to pursue settlement agreements and consent decrees whenever feasible. I don't intend my comments to suggest it's always inappropriate for a settlement agreement to provide some definition and scope to a proposed rule. However, my overarching recommendation to this subcommittee is to address and improve the process by which these agreements are reached in the first instance. By promoting fairness, transparency, and public participation of interested stakeholders in the first instance, settlement agreements will better reflect a wide range of interests that must be balanced, result in stronger and more defensible outcomes, and improve the success of the subsequent rulemaking process. Thank you very much for this opportunity today to share my views.
Thank you. Mr. Cox.
Thank you, Mr. Chairman and members of the committee. I'm going to discuss, I'm not going to try to go over old ground that others have discussed, so I'm going to briefly hit sue and settle, but I also would like to talk about how it impacts jobs, and I think that's where the business community really comes in. But in essence, sue and settle is really a good government's concern. It's transparency, public participation, and the impact on jobs. And really what we're talking about is when you look at sue and settle, this is a subset of the interested community that's actually entering into contract negotiations. They are contracts. When the contract is decided, it's decided without the rest of the public involved. And I think from the business community point of view, being involved in those contract negotiations should be a fundamental right that we have under the Administrative Procedure Act, which the Congress passed decades ago to literally open up the process to the citizen and for participation between the citizens. And so when this contract is executed and it's filed with the court doesn't review the substance. What the court does is the court reviews the representations of the parties. And when it enters a judgment, that judgment cannot be disturbed unless it's shown that there's an abuse of discretion by the court, which is an almost impossible standard. And then when the final rule comes out, even if it's identical to what the agency and the environmental groups thought, our chances of overturning that based on an arbitrary and capricious standard are very, very low. So once the contract is made, the decision is made as to how to go forward. But let me talk about the more practical aspects of it. Environmental litigation is costing this country tens of thousands and hundreds of thousands and millions of jobs. In 2010, the U.S. Chamber did a study called Project No Project, and we looked at environmental litigation across the country from the point of view of what was the private sector trying to finance in 2010. And we looked at just electric generation. We could have looked at cell towers, big box stores, cement companies. We could have looked at anything. We looked simply at electric generation. There were 351 projects where developers were trying to get permits. They could not get the permits, and the impact of not getting the permits meant that they could not invest $576 billion, which would have created 1.9 million jobs a year during the 7 years of construction. That is the impact of environmental litigation. There are ways to address it, and the Judiciary Committee is doing some of that. That's not my point here. The second point in sue and settle, and this is very, very specific because there's great data from the Department of Labor. When sue and settle occurs, it's a specific regulation on a specific industry. Take Utility MAC, take NSPS, take whatever you want, but that regulation is targeted at an industry. Jobs will be lost in that industry. And let's assume that everything that the other side says is true, that jobs are created somewhere and there's full employment everywhere, and in fact more jobs are created. But what your own statistics from your Department of Labor show is that the jobs that are created aren't created in the same communities, they're created in different communities. So what happens is you have a real person with a real job that's lost and a real community that's impacted. And then on the other side of the equation, you have jobs created somewhere that they can't get. Let me give you the statistics, because this is really what the key is. The Bureau of Labor Statistics, every 3 years, does a study of displaced workers. And the sampling is of about, just so we've got the numbers, 15 million workers. And of the 7 million workers that were what we would call long-term displaced, they didn't have a job for 3 years, or they had worked for 17 years, but were out of a job during the survey. Out of those 7 million workers, a majority of those workers were not able to get a job during the entire survey period. Meaning that if the survey was 2007 to 2009, in 2010, 51% of those workers did not have jobs. Now that's displaced from all, and we've got to keep that in mind. But once you lose a job in an impacted area, you're not going to get another one. And of the 49% who actually ended up getting jobs, we have 55% getting lower wages. So when you look at the impact of regulations, you look at it in litigation, you look at it twofold. One is you don't create the jobs, and that I think the Project No Project study clearly determines. And the second part of it is when you lose a job due to a regulation, even if jobs are created in other industries, that community is really impacted and that worker is impacted. And that's something we have to keep in mind. And the most frustrating part is that since 1977, this Congress mandated that EPA do a continuing analysis of job loss and shifts in employment due to regulations. And in 35 years, the agency has never conducted that study. And this is what's so frustrating about it. On one hand, we want to turn everything into a mandate and let the agency do what it wants, but Congress can give the agency a mandate to worry about jobs, and the agency won't do it. Thank you very much.
Thank you, Mr. Kovacs. Mr. Boyd, I know you've got to be able to scoot out of here as well. You're excused from the panel.
Thank you,
Mr.
Mr. Chairman.
Percival, thank you for being here. Mr. Percival.
Thank you, Mr. Chairman. Oh.
It's a good example of sharing right here. Look at this. It's all coming at you.
It's good that we can be so cooperative. Thank you, Mr. Chairman.
See if the green light's on.
Yes, it's on. Thank you, Mr. Chairman. Thank you for inviting me.
Still not on.
You want to try mine?
Yeah, I'll try yours.
There we go.
Okay.
Thank you.
Thank you, Mr. Chairman. I'm Robert Percival, the Director of the Environmental Law Program at the University of Maryland Law School. I'm afraid I'm going to be a bit of a skunk at the party. I've been practicing environmental law for 31 years. When I first started practicing environmental law, it was during the early days of the Reagan administration. And what I've heard here today is complaints about how environmental regulation, which had long been a bipartisan issue, is killing jobs and killing the economy. Every time a new major program was being implemented, the feature of environmental law in the United States that has so distinguished us is the fact that we have citizen participation. We allow for citizen suits, and virtually every major program had to be implemented only because the agencies were forced by citizen suits to implement it. As Congresswoman Spire indicated, most lawsuits brought against the EPA are actually brought by industry groups. That's part of the system. We allow ordinary citizens to go into court to make sure that EPA abides by the law. When the Reagan administration proposed to phase lead out of gasoline, there were cries of doom. We were going to have gasoline shortages. It's been one of the most successful environmental regulations in the world, adopted by virtually every country in the world. We had a very healthy economy until the global economic problems in 2008. At the same time, we had environmental law that made us the envy of the world. All you have to do is go to China, as I do fairly regularly, and you see these young public interest lawyers in China who would love to have a system like we have where they can hold their government accountable. And what I've heard today is that illegal regulations are being adopted, that the public's being cut out of the process because of these settlements. Similar charges were investigated way back in the Reagan administration in 1986 when Attorney General Edwin Meese came up with the Meese Memorandum to provide guidelines for what agencies could agree to when they reach settlements. And as I indicated in my testimony, settlements are a prominent feature of the U.S. legal system, and they're expressly favored by public policy because they have so many benefits. The characterization of collusive litigation and sue and settle, I believe, is simply a fantasy. To be sure, agency policies are going to change when there's a change in presidential administration. Administrations have the ability to change course, and if we have a new Republican administration coming into office in January, you may see a situation where EPA is more frequently reaching settlements with industry groups, but there has not been any change in EPA that has in any way cut out the public from the process. There are already very important safeguards that prevent that. Standing requirements that require concrete adverseness among litigants, the need to obtain judicial approval of settlements, and most importantly, the requirements of the Administrative Procedure Act that preclude agencies from making commitments concerning the substance of rules. The DC Circuit and other U.S. courts of appeal have not been shy about striking down EPA regulations, as Mr. Martello well knows, if they are in fact illegal or if the Administrative Procedure Act has been violated. But the charge that EPA is out of control and as a result acting illegally, I think was quite well refuted on Tuesday when the DC Circuit came down with its Coalition for Responsible Regulation versus EPA decision, upholding EPA's greenhouse gas regulations, saying that everything EPA did essentially was correct. So I simply am not on board with the notion that we need to do more to discourage settlements. I think that will only make it more difficult for agencies to benefit the public, whether it's in a Democratic administration or a future Republican administration. Thank you.
Thank you, Mr. Birchall. Mr. Jabin.
Chairman Langford, distinguished members of the subcommittee, thank you very much for inviting me to testify this morning. My name is William Yateman. I work at the Competitive Enterprise Institute. We are a free market think tank here in Washington, D.C. Wonderful, getting a visual aid. I'm here this morning to speak to you about how EPA is using the sue and settle, so-called sue and settle consent decrees to usurp the state's rightful authority on regional haze. First, a short primer on the regional haze regulation. It's a Clean Air Act regulation, and its purpose is to improve the view at national parks and wilderness areas. This point bears repeating. It's an aesthetic regulation, not a public health regulation. Due to this fact, the Congress intended for the states to be the lead decision makers on regional haze policy, on visibility improvement policy. Despite state primacy, the Environmental Protection Agency has already imposed 3 federal implementation plans for regional haze on Oklahoma, New Mexico, and North Dakota over the staunch objection of state officials. EPA's plans would cost almost $400 million per year more than the state's plans, which were crafted with all due process over the course of years. Sue and settle featured prominently in EPA's actions in these federal implementation plans, and I'll briefly sketch out how it worked for each of these states. In a Northern California court, EPA agreed to deadlines on regional haze as part of a settlement agreement with Wild Earth Guardians. The states were not notified and were not part of this agreement, or notified after the fact, but were not part of this agreement. On the eve of the consent decree deadline, EPA objected to the process used by states for their regional haze determinations. They didn't take on their determinations directly due to state primacy accorded by the Clean Air Act on regional haze policy. Instead, they objected to the process. Usually it was the state's cost effectiveness analysis. That's what they went after. This didn't reject the state's plan outright, rather it held it in abeyance, sort of a holding pattern. Then EPA claimed that pursuant to the consent decree, it had no choice but to run roughshod over the state and impose its own preferred plan, federal implementation plan. So that's how it's worked in each of these 3 states, this 3-part strategy. Already, and as I mentioned, Oklahoma, New Mexico, and North Dakota, $400 million per year of costs over what the states had determined was necessary to comply with the regional haze rule. EPA's proposed FIPS for Wyoming and Nebraska, these would cost $120 million per year more than the states planned. Utah and Arkansas are likely next. And for what? What is the ultimate benefit of these federal implementation plans? Thanks to Colorado State University professors have actually created software that allows us to visualize visibility impairment. It's known as WinHaze. It's available on the internet for free. I downloaded that software. I input the EPA's own data, its own baseline data, and its own visibility improvement data. What I found was rather striking. I've got two images to convey what I did find. On the left here, this is Oklahoma, Wichita Mountains National Park. This is the most affected Class 1 area of the EPA's federal implementation plan for Oklahoma. This is the result of these are the benefits, the putative benefits of the regulation right here. On the left, we've got the state's controls. On the right, we've got EPA's controls. Notably, this is the largest disparity between state and EPA controls. This is the biggest improvement engendered by any of EPA's actions on regional haze to date. This improvement, quote unquote, was worth $282 million per year in control costs and compliance costs. So this is a side-by-side photo. Up on the monitor, oh jeepers, we had it there right before, but perhaps it's not there anymore. We'll get it back. Up on the monitor, in addition to side-by-side images, WinHaze, the aforementioned software, allows us to do split images. So it's in essence a melding of the two. On the left half, those are the state controls. On the right half, right 50%, those are EPA's controls. The split image is meant to accentuate any difference between the two visibility results. As you can tell, or at least certainly as to my eyes, there is no difference. Even the split image, which is supposed to accentuate the difference, is invisible. I cannot tell a difference. Last night at the Competitive Enterprise Institute, I lined up my colleagues and had them each look at this placard. None of them could distinguish a difference. So in essence, it appears to be all pain and no gain with respect to this regional haze regulation. And that concludes my testimony. I look forward to taking your questions. Thank you very much.
Thank you. Thank you to all of you. Now recognize myself for 5 minutes, and we'll begin some rounds of questions here. Mr. Martella, you've dealt with this in the past. Tell me what is typical in the EPA for a consent decree and working through the process? Because you had mentioned it's not inappropriate, and I would agree to you that not all settlements are inappropriate. But you also outlined a couple key statements. You said that we have to deal with the public policy and make sure the public is engaged in that. What would you set as a policy for this? Mr. Purcell mentioned the Meese memo on it in the past. Is there a certain process that you would look at for that?
Sure, and thank you for the question. I would like to clarify that I fully support settlements and consent decrees in every opportunity. In an ideal world, all litigation would be settled. I was a Justice Department attorney before EPA, and my incentive was always to settle over going to trial as it is today. I think, though, you have to look at a number of factors, and the first beginning the merits of the case that's coming in. It's not in the government's interest to be settling frivolous cases. And so if a group, whether it's an industry group or an NGO group, I'm not trying to preference one over another, any group that comes in the EPA and says, we're going to assert this frivolous claim to get you to do something, will you settle it with us? The agency should be comfortable standing up in court and telling the court this is frivolous, we're not going to be giving up our discretionary obligations just because somebody wants us to. I think, unfortunately, that is my gripe, is that I'm seeing a lack of willingness to defend cases that I think are frivolous, or at least where legitimate arguments could be made to defend them. And the result is shifting resources. All of a sudden, EPA is now adopting the folks who are coming in, their policies and their priorities, as opposed to what the agency's priorities are.
Let me ask you about that then. The citizen suits that are set out there are really designed to force EPA to do its mandatory responsibilities. Am I correct on that?
That's exactly what the intent should be, yes.
Correct. So if a citizen suit pushes them to do a discretionary responsibility, has that extended the NGO's ability to be able to then take something that is uniquely EPA's responsibility?
I think that's fundamentally kind of transforming the purpose of the citizen suit. Citizen suit, as you point out, is the government was required to do something, it didn't do it. When you now enter the realm of, we're going to make you do something you're not required to do because we think it's important, even if you don't think it's important, The government has limited resources, and that becomes a fundamental reallocation of resources.
Can a citizen suit also create a new policy, change previous policy, and create a new policy off a citizen suit?
Right, and we saw that in the new source performance.
Is that
example.
appropriate? Is that an appropriate use of a consent decree?
I don't believe that's what Congress intended.
So we got some basics here. If it is a mandatory responsibility and it doesn't extend to new policy, then you would suggest that is a better policy. That if a consent decree creates new policy or expands an existing policy, or if it mandates something for future administrations of something that's clearly discretionary, then it's also expanded beyond its bounds.
I would agree with that.
Are you familiar with the Meese memorandum Ms. Percival mentioned before?
Yes, sir.
I'd ask unanimous consent to submit the Meese memorandum for the record without objection. This highlights three areas. It says the department or agency should not enter into a consent decree that converts into a mandatory duty otherwise discretionary authority. The second aspect of this is the department or agency should not enter into a consent decree that either commits the department or agency to expend funds that Congress has not appropriated and that have not been budgeted for the action or question. And the third thing, the department or agency should not enter into a consent decree that divests the secretary or agency, administrator, or his successors of discretion committed to him by Congress or the Constitution where such discretionary power was granted, or changing with the changing of circumstances. Any issues with those three?
I think those are principles that I would hope would be vigorously applied today. They're sound principles, both intended to preserve the government's own ability to set its own policies, but also avoid an infinite loop where people are constantly forcing the government to new obligations that it can't meet, and people go back to court and ends up being less efficient for the courts.
Right. Yeah. This is currently not what we're doing now, right?
I would argue we've given examples today of things that are inconsistent with those principles.
This is really about process. This is not about trying to throw out all citizen suit possibilities. This is about trying to see if process is being followed through correctly, and if we're achieving the end result, or if we're creating new legislation in a way that is outside of this Congress.
It's about public participation. It's about transparency. It's about affirming the principles in the Administrative Procedure Act that Professor Percival referred to.
I was very interested in the fact that when the consent decree was formed dealing with Oklahoma, when that decree was formed, there were some timelines that were set on those, and for those timelines to change or to get an extension of those timelines, the state of Oklahoma would have to return to the environmental groups to request permission for an extension of the timeline. Do you see that being appropriate, that a state would go to an environmental group to request permission to have an extension with the EPA? Does that seem like an appropriate extension to you?
I don't want to speak for the Attorney General, but I would imagine that states would be very concerned about their sovereignty being intruded upon.
That seems just a little odd to me, that in a consent decree that's been signed off on, that we don't come back to the EPA for an extension permission. We go back to environmental groups to acquire permission for that. So with that, I'd like to recognize Ms. Spear for 5 minutes.
Mr. Chairman, thank you. And let me say at the outset that I have a great deal of respect for the chairman. I think there's some issues here that could really be looked at, and I'm willing to do them. But I must say that doing it in this manner doesn't get us to a constructive resolution. To Mr. Martella, you had suggested that maybe sometimes we should be defending cases. I think one of the questions we need to ask is there enough staff to defend these cases? If you don't have enough staff to defend the cases, then sue and settle is exactly where you're going to go. To Mr. Kovacs, your comments about regulation and how it's a job killer is something that is articulated over and over again. But I look to the deregulation of the financial services industry with the Gramm-Leach-Bliley Act and with a number of laws that were passed by this Congress after that act. And we now have 15 million people out of work in this country because the financial service industry came to a shutdown, and this government had to bail out that industry to the tune of over $1 trillion. So in terms of jobs loss, I think you can make the case that when you deregulate sometimes, there is greater job loss. Now, to you, Dr. Percival, I'm going to turn over the rest of my time to you because I believe this hearing is frankly not as constructive as it could be. I'd like to do a whole hearing on the haze in Oklahoma because if in fact that is what is presented by Mr. Yeatman, then we should look at it. And we shouldn't have third parties dictating to states whether or not there's an extension. Those are legitimate issues we should be talking about. But I'm not interested in kangaroo hearings, and that's what I think this is. So, Professor, please make any comments you would like to make about what everyone else has said.
Thank you.
Thank you. I still, come back to the point that this is not a situation where third parties are dictating what regulations are adopted. That still has to be done through the Administrative Procedure Act. Now, it is true that EPA, when it fails to perform a mandatory duty, then can be hauled into court, and a schedule is negotiated for how you're going to cure this violation of law. The Meese memorandum, which I wrote the law review article that I submitted with my testimony about, I thought was unwise policy because it was designed essentially to say that the only remedy for the government not carrying out the commitments we make in a settlement should be reviving the litigation rather than having an enforceable consent decree that actually increased the value of the government's word. Now, you say, if it's true that the Hayes rules are outrageous and illegal, the 10th Circuit steps in, you get them overturned in court. We have that open process, and EPA will have wasted a whole lot of time doing something illegal. People said that's what they were doing with respect to greenhouse gas emissions, but the DC Circuit has confirmed that that certainly wasn't the case. The argument that somehow this private group is going to be able to dictate whether or not there can be an extension of time. If EPA feels it needs an extension of time, it can ask the court for an extension of time, and its word is probably going to be given some deference. But what we've seen in case after case is situation where rules that Congress mandated be adopted a decade ago still have not been promulgated, and deadline after deadline passes, and sometimes courts say enough is enough, and the rule ends up getting promulgated. But as I mentioned in my testimony, even then the agency's free to reconsider them if they think that the rules are not adequately supported.
You have more time.
Oh, okay. Oh, so what I would like to emphasize is that this is well-trod territory. Since 1986, when there was the big kerfuffle over the Meese memorandum, this charge was made that somehow environmental groups were dictating the priorities of EPA. When everyone looked into it, it turned out it wasn't true then. There's absolutely nothing that has fundamentally changed about EPA during the Obama administration. It's not a situation where the agency is being dictated to by a group of environmental groups. And if in fact it's true that the agency is being sued in a situation where it does not have a mandatory duty, then the plaintiffs don't have a leg up in court. They don't have any possibility of winning that lawsuit. And that can be challenged if when the court is trying to approve a consent decree, if in fact they're trying to say this is a mandatory duty and it's not. So I'm saying the system works pretty well for both industry and environmental groups. EPA unfortunately gets beat up on by all sides, has its budget cut and the like, and the result is that you see a situation where the agency is always the boogeyman, and occasionally, because our judiciary functions so well, you see a decision like the decision on Tuesday upholding the greenhouse gas regulations that tells the agency you are doing something that in fact complies completely with the law.
Thank you.
Thank you. I'd like to recognize Mr. Kelly for 5 minutes.
And I thank the chairman. I do believe this is, I would not use the term kangaroo court. I really am interested, Mr. Martella. I've watched this, and coming from Pennsylvania, I'm watching now what's going on. If we go to just to a little bit of background, we're having coal plants shut down, all right? And I know that there's 11 plants in Pennsylvania that are shutting down. Slide number 3, if you could just go to that, please, for a minute. And this is the president before he became president. So if somebody wants to build a coal-powered plant, they can. It's just that it will bankrupt them because they're going to be charged a huge sum of money for all that greenhouse gas that's being emitted. Now, I watched another clip this morning of the president explaining how cap and trade would work, and because some people just don't get it, so you have to force feed them into this, which I think is kind of an unusual take on things. I think there's a much better way to do it. With new source performance standards, let me ask you, what was the Sierra Club? What was their involvement in the new source performance standards?
Well, what we know is in December of 2008, the Sierra Club wrote an article that was public saying that their goal for the administration was to set a new source performance standard that would make sure that no new coal-fired power plant could be built. 2 years after that, the administration entered into a settlement with them, setting a deadline for proposing such a standard. That agreement was entered into. It affected both utilities and refineries, but no one ever consulted with the utilities and refineries in setting the schedule. Just a couple months ago in March, the EPA enacted the very proposal that looked identical to what Sierra Club had written in 2008, and again, without any prior consultation with the industries actually impacted by the substance of the proposal.
Yeah, so without objection, Mr. Chairman, I wanted to enter into the record the newsletter from the Sierra Club. But I'm interested because this process that takes place, you call it an off-ramp decision. And so for those of us that come from the normal world, the regular world, the common sense, and I don't mean to in any way diminish people that come from the legal world where they use things don't have to make sense to you. In the common sense, you have to have a law degree to understand some of it. I believe that if you're not at the table, you're on the menu. So when we have these decisions being made by groups and it comes forward like that, would you have, in your former position as the EPA, would you have litigated the new source performance standards?
I believe, I would have liked to have seen the government stand up in court and explain why it should not be forced to do this. And in fact, Congress has given EPA a process that would have solved this for everybody without having invoked this impact. EPA could have done an advance notice of proposed rulemaking that would have allowed it to study the issue. Everyone could have been at the table. I share your point. Everyone should be at the table, but it wouldn't have had the immediate impact of shutting down coal-fired power plants. So there clearly was an option before EPA that I would have advocated for to go with an advance notice of proposed rulemaking that would not have had the immediate impact while shutting folks out.
Okay, so was there a mandatory duty? I mean,
I would have been, if I was back at the Justice Department, I would have been very happy to stand up in court and argue to the court there was no mandatory duty here. I would have felt very comfortable with that argument.
Yeah, and I think, listen, I don't think there's anybody in this country that doesn't want clean air and clean water. I think we all are certain of that, but there's also a factor of our economic freedom. And as we continue to take a look at this, I'm just trying to come out of the private sector understanding as we continue to turn our back on things that are very abundant, accessible, and affordable, which I believe in the fossils. We're turning our back on those and going to in another direction that really costs the American consumer, which is who we represent, the American people, not just Republicans or Democrats, but everybody. Their cost of living under some of these new regulations are going to skyrocket because energy costs are going off the board. And as I said, in Pennsylvania, we see power plants shutting down all the time. And the trend is, okay, well, fine, we're going to go to natural gas. And now we're finding out, you know what? Well, you know what? That's a little bit better than coal, but we're finding problems with that too. So sometimes you can mandate yourself into a situation where it's totally untenable. Mr. Kovacs, because I do believe it's about jobs, I really do. And if we're going to turn this thing around that we're in right now, this decline that we're in, it's going to be about getting people back to work and having more people being able to attain a standard of living that makes sense and they can support a family on. There's a slide. If we can go to slide number 4, I think this is really something that we need to take a look at. This is a statement that was made by Curtis Spalding. He says, Lisa Jackson has put forth a very powerful message to the country. Just 2 days ago, the decision on greenhouse gas performance standards and saying basically gas plants are the performance standards, which means if you want to build a coal plant, you got a big problem. This was a huge decision. You can't imagine how tough that was because you've got to remember, if you go to West Virginia, Pennsylvania, and all those places, you have coal communities who depend on coal. And to say that we just think those communities should just go away, we can't do that. But she has to do what the law and the policy suggested, and it's painful. It's painful every step of the way. Now, this is about jobs, and you mentioned some metrics about the numbers of jobs that were being walked away from.
The Bureau of Labor Statistics does this displaced worker survey, and it's 7 million, so this isn't a random survey. It's 7 million for long-term employed. If you take long-term, short-term, it's 15 million. So we're talking about whoever is unemployed and displaced.
Let him do it.
And what it finds is that the workers who lose a job, the long-term workers, the coal miner, the person who works in the utility plant, does not get a job within the survey period, which is a 3-year period. And that after the survey period, 51% of those long-term workers who were unemployed, and this is going to a regulation that takes an industry out, though 51% of those still did not have jobs afterwards. And of the 49% who got jobs, 55% were below the what they made before. So that's the impact, and that the jobs that are created, if you take a job out of Pennsylvania or West Virginia and you build a battery plant in Michigan or California, they're different workers. So you have a real life impact on the workers in where the displacement occurs, and you have a theoretically or modeled worker somewhere else. But the second point, which is I think more important, is that since 1977, Congress imposed mandated a duty on EPA, the language is shall, mandated that when they do a major regulation, that they do a jobs analysis and a shift in employment analysis. And that was specifically to find out what is the impact of these major economic regulations. And EPA has never done that, and that is mandatory. And what I think, and this is my last point, as I listen to this, we're talking about mandatory duties, discretionary duties, and how do you convert them? But here's a clear example of a mandatory duty that EPA has never attempted even to do. And that's really where I think the disgrace is, because that they had the opportunity to link up what they were doing with the Bureau of Labor Statistics are doing, and to find out what the impact of the regulations are. And if there was true public participation and they truly cared about jobs, then they would be doing that analysis.
Thank you.
Thank you. I'd like to recognize Ranking Member Mr. Conley.
Mr. Chairman, I know at the full committee we've descended into the bad habit of prejudging the outcome of a hearing in the selection of the title. I had hoped we would not do that in this subcommittee. To have a hearing entitled Mandate Madness when sue and settle just isn't enough kind of gives away the game. I don't think it's an intellectually honest pursuit. I don't think this hearing is an intellectually honest pursuit. I'm glad, I guess, you've provided a forum for folks who don't like the Environmental Protection Agency or don't like environmental regulation to have a forum. And I can't express enough my disappointment in the structure of this hearing and in the title itself. I am all for an honest intellectual pursuit of the issue of unfunded mandates or burdensome mandates that may in fact be unproductive. I come from local government where we had to struggle with that ourselves, and I'm not unsympathetic, but to basically simply provide a forum for ranting about the EPA and its mission with very little empirical evidence to back it up is very troubling to this member of Congress. And I had hoped we would continue or try to continue a tradition in this subcommittee where we actually pursue issues in as neutral and objective a way as possible. I don't think that's going to happen here. And I register my disappointment. I yield back.
I would say that it might be good to go through some of the notes and the testimony and such that is here to be able to examine the process and how things have significantly changed in the process of this, because there has been a significant change. This issue is a process issue, and that has shifted, and it needs to be an appropriate process so citizens have the opportunity to be able to hear and be heard.
Mr. Chairman, may I ask, I mean, is it your contention that the title of a hearing called Mandate Madness is an objective title? That's just an objective, honest pursuit of public policy?
You know, the hearing itself deals with the policy issues. This is not a hearing about a title. This is a hearing about the facts in the case.
Titles matter, Mr. Chairman.
Yes, they do, but the facts matter even more.
Well, I think the facts get skewed when the title clearly channels those facts in a certain direction.
Well, fortunately, this is not a court, This is a case where we have to bring things to light,
It
and it has been done by,
It most certainly is not a court. Otherwise, a fair hearing on both sides would in fact be provided.
would be glad to have a fair hearing for all people involved, since we have consent decrees that don't give a fair hearing to all involved. That'd be wonderful.
That's your opinion, sir. That's not my opinion.
I'd like to recognize Mr. Labrador.
Mr. Chairman, that's actually the purpose of a hearing is to share both opinions, but apparently one side only wants their opinion heard and not the other. And we've actually been holding a hearing so we can give the other side the opportunity for them to actually state their opinions, but instead they want to just make statements about the fairness or unfairness of this hearing, which is rather shameful. Mr. Kovac, I just have two questions for you, and then take as much time as you want, and then I'll yield the rest of my time to the chairman. But I just heard Professor Percival state that there has been no change between the Bush administration and the Obama administration with respect to the EPA. Can you recall who in the Bush administration said that there was a plan to crucify regulated industries? Do you know what I'm referring to? Can you explain what the change has been between the Bush administration and the Obama administration?
Well, certainly let's take a step back as I answer this, and to make it very clear, we're not here to argue that we want to eliminate citizen suits or what is mandatory and what is discretionary. We're here to say that as the EPA begins to exercise its discretion as to whether to sue or not, that the impacted parties need a seat at the table. And by a seat, we don't mean sitting there and negotiating, but when the environmental group and the EPA come to that understanding, before it is filed with the court and has a court order attached to it, that it go out for comment, and that if there's an impact on the regulated community, that they have a right to use intervention within that court. Right now, the regulated community is locked out of that process. And so what happens, as I explained in my opening statement, is once the decision is made, the chances, and there's a court order, the chances of reversing that are virtually nil through the process. That decision has been made. So when you get into asking the question, how have things been different? The issue of sue and settle has been around for decades, and that's why you have the Meese memo. The Reagan administration looked at it and said, this is not a process that the government should be actively involved in, because it's ceding the discretion of the agency to private groups who then, because of the consent decree, literally have an involvement in that issue forever. And just the comment was made before, well, you have to go back to the environmental group to change the deadlines. The private party actually, by contract, gets a right. Let me repeat this. The private party, by contract, gets a right to be part of the supervision, not the regulated community. And frankly, EPA cedes its authority. So what has changed is, although you had sue and settle agreements going on for decades, right now you have, as the chairman mentioned in his opening, somewhere around 60 of them. And they're filed, like in Regional Haze that William Yateman was talking about. The states of Oklahoma, North Dakota, and New Mexico were involved, but the lawsuit was brought in Oakland, California. And so the first notice that the states and the attorney generals and the governor had was when the settlement agreement was actually entered and approved by the courts, and then they got notice. So what's changed is it's gone from a few a year to being the policy of the administration. That's the change, and that's the 60 of them that you have. And in some of these instances, to give you an idea of how broad they are, there was one in Oakland, California, it seems to be a popular court, where there were actually 28 rules that were subject to one consent decree regulating 2/3 of the industries in the United States.
Excellent. And I liked some of your comments. You said that the decision has already been made, that there's been no opportunity to be heard, but yet this hearing is being called a kangaroo court. Yeah, I find that really fascinating. As you know, the Endangered Species Act is often the premise to these sue and settle rulemakings. Last week I was in a different hearing, natural resources hearing, and we heard testimony that the ESA actually creates jobs. In your experience, how does the ESA actually create jobs?
Well, I always go back to Milton Friedman's comment when he was in China one time, and he was asking why they were building a dam with shovels, and the Chinese replied, well, that's what the regulations call for, because we're trying to create jobs through in essence, through regulation. And Friedman's remark was, well, if that's the case, why don't you just use spoons? You'll create more. So the purpose of a regulation should be to undertake and to achieve what Congress intends it, the public interest. And for example, in the endangered species, I think, you do have a situation where you're going to have more boots on the ground, you're going to have more inspectors, you're going to have more government paperwork, you're going to have more petitions for protection. You're going to create jobs there, but the key is you lose jobs because the land that's impacted, and if you go into some of the energy issues, in many instances is so vast that you've taken large areas of the United States out of development. And that's why I keep on coming back to the Bureau of Labor Statistics, displaced workers. When a regulation comes in, it impacts a specific industry, whether it be coal, cement, logging. We've got a lot of instances of that. And maybe jobs are created in Washington, D.C., but the jobs that are lost in Pennsylvania or New Mexico are not the same, these people do not get the jobs in Washington, D.C. And it's the community that's displaced. And I keep on coming back. These are real workers who are really displaced, whose families are displaced, whose communities are harmed. And that doesn't mean that jobs aren't created somewhere else. They might be, but that community has been harmed by that regulation.
Thank you. Mr. Chairman, it's been my experience as a practicing attorney for 15 years and just observing, debates, that when you can't debate the facts, you resort to ad hominem attacks. You're one of the people I respect the most here in Congress. You've been one of those most fair individuals, and to come here this morning and listen to two different members of the minority attack you personally has been pretty distasteful. I thought I was just coming to a regular hearing, actually a pretty boring hearing. I thought that it was going to be, but maybe what we should do is see if the opinions of the chairman or the opinions of the ranking member prevail after having a full and fair hearing this morning. I yield back.
This is
Mr. Chairman?
This is, well, just a moment, I will definitely yield to you. This is what makes America a great country, is that we do have divergent opinions, and all opinions are open here. Of all places in the House of Representatives, every opinion should be heard on that one. But that would be honored to yield to the ranking.
Mr. Chairman, I want to directly respond to my colleague. No ad hominem attack was made against Mr. Langford. My remarks were strictly limited to the nature of this hearing.
He is the chairman.
Well, he may be. I'm the ranking member of this chairman. I still don't like the hearing, and I'm entitled to not like the hearing. I have never cast a negative word about Mr. Langford. In fact, we've worked well together. I consider him a friend. And I would ask you to withdraw those words, because no ad hominem attack was ever made against Mr. Langford in this hearing.
Before you got here, Mr. Connolly, this was called a kangaroo court by a member of your party. You came in and you had some pretty distasteful statements about this. So I came this morning to hear both sides.
Mr. Labrador,
And
I can't any more than you can. You can't take responsibility for other members of your party. I can take responsibility for my remarks. I think you would agree, since you pointed out you practice law for so pretend you're in a courtroom. What you heard from the ranking member of this subcommittee was a critique of the intellectual foundation of this hearing and a critique of the nature of the title of this hearing that I consider to be intellectually dishonest. None of that had anything to do with Mr. Langford as a person or as the chairman of this committee, other than I don't like the judgment exercised. But that's not about him personally. Would you not agree?
we can agree to disagree. Thank you.
Mr. Chairman, I would have hoped my colleague would have given me the courtesy of acknowledging no ad hominem attack was made against you by this member.
I have no further comments. I just made my comments because I was surprised by the nature of the attacks from your side. That's, but we don't need to debate this.
Well, Mr. Chairman, a charge was made that an ad hominem attack was made. I would point out to Mr. Labrador, there are actually rules in the House of Representatives about ad hominem attacks.
Mr. Chairman, could I ask you to go into regular order, please?
We do need to move on, Mr. Conley. I'm going to do a quick round here, and would be honored to be able to yield you time in that time, and just to be able to allow all voices to be heard, all opinions to be heard.
I would have thought a point of personal privilege would have been respected, Mr. Chairman.
Well, it has been. I'd like to just do a 3-minute round here of questions so we can do some follow-up on it and get a chance to pull some things together. I'd like to also submit for the record, asking unanimous consent, a letter from the Association of Builders and Contractors. They make a statement in this letter with that so ordered. It says, when settlements are agreed to, they often mandate that rulemakings go forward and frequently establish arbitrary timeframes for completion without stakeholder review or public comment, and they continue on from there. Where this originated from was over the past year and a half in multiple hearings and multiple settings that I've been in. I've heard members in leadership and individuals who work with EPA say to me, we have to do that because the court ordered us to do that. I couldn't point to a specific piece. It was a court order that mandated us to do that. So it started me on a journey to go back and start to pull some of these court orders and to say, where did that court order come from and exactly what did they order? What I found is many of these consent decrees did not order them directly to take a specific action, order them to review policy, as is appropriate, if it had not been reviewed and it was a mandatory responsibility. But then they took that statement of it has to be reviewed and greatly expanded where it would go and then hid behind the statement. We were ordered by a court to do that. We were also, new policies were created. The NSPS, as Mr. Kelly mentioned before, where it went from new construction to now existing construction. Well, that's entirely new policy that's been created by it without public comment, without input in the stakeholders. That's something uniquely different than we're just creating some sort of regulation, running it through the Administrative Procedures Act. Now we're creating new policy based on a consent decree. That's a giant shift in what has occurred. There are also moments where outside litigants are placed in authority over states, where states are not given primacy to make a decision. Now they have to request permission of a litigant, and the states were not given the opportunity to be at the table. What we have is a situation where the people that are affected by it do not have the opportunity to actually address their grievance. They don't have an opportunity to be able to express that unless they have a court case, unless they go through a process and try to reverse something, which is difficult to do. As Attorney General Pruitt mentioned before, we're currently in the 10th Circuit in Oklahoma and just had a stay because it was extended too far. It was a case gone too far. Now that's very difficult when you're planning for power plant construction that is incredibly expensive and very capital intensive. Now you don't know what the rules are. And at any moment they could shift and you have to sue and counter-sue and to try to work through the process all the time planning on a $1 billion construction project. This creates instability. We have a stable process for this. And the concern is that we're shifting away from that stable process. And we're now creating regulations based on preferences and based on a consent decree without the appropriate people at the table. And I'm simply asking the question, who sets the timelines? Who comes up with this? Who has the opportunity to actually speak and comment into these issues? And shouldn't it be the people that are affected? With that, I'd like to recognize Mr. Connolly for 3 minutes.
Mr. Chairman, I have no questions to this panel.
Mr. Kelly.
Thank you, Chairman. And Mr. Martell, I want to go back to this because I think what the Chairman is hitting on is something that's very critical here. Of course, it looks at the court's only accepting the parties' agreement to settle and not adjudicating whether the EPA's legal position is correct. And I think that goes to the crux of the problem. Now, we can tap dance around all the other issues, but the truth of the matter is when we change and there's a new administration that comes in, they also have the ability to appoint to these different agencies the structure of it and how it's going to go forward. So if I have an agenda in place, what I do is I place into effect people who are going to go along with my agenda, and then I tell them, you know what, we've got a problem, we can't legislate it, could you possibly take us to court, sue us, and then we'll settle out of court, and then it will become law without the judiciary. So please explain that to people, because I think that's where we're missing the point today.
And I think, that's the contrast between what our democratic system, wants and then what is happening in some cases. Our system is all about transparency. That the notion that government leaders are not going into back rooms with a subset of folks who are interested by things. It's all about public participation, that everyone has an equal role to play in a process, and it's about having an opportunity to challenge things in court. I think some of the examples you've heard today, again, we're not here to say settlements are bad things. What we're worried about is when we don't have that level playing field of transparency and public participation. And just to give you one more example, back to NSPS, when EPA entered the consent decree with NGOs, there were other parties in the litigation. Trade associations had intervened. And in order to intervene in a case, it's not automatic. You have to prove to a court that you're adversely impacted. You could be adversely impacted by this case. And then the court says, okay, you could be harmed here, so I'm going to give you a right to participate. The concern with the NSPS is, despite the fact the court had already found those parties could be adversely impacted, they were at no point part of the settlement discussions. They were never brought into the room. And that's what, to me, I think is kind of the fundamental flaw I have with our notion of transparency and public participation.
And I've got to tell you, when I'm back home in Western Pennsylvania, you know what, the thing about the American people, they trust us so much with the process, and they have great faith in the process until they find out they've been gamed. And so if I can effectively structure a situation to come out with the answer that I need or that I want, and somehow do an end run, that's not what made America great. And I think that's the thing that frustrates us all. And when we look at why people are losing faith in the way the federal government works, it is because we have been able to take what was there and available to us and tools that were supposed to be there for all people, and we've gamed them by people who know how to maneuver. And I got to tell you, it is deeply disappointing to me to sit and watch this and have it come down to something that it was never supposed to. It's morphed into something entirely different than what the American people believe, what they have faith in, and what the founders started off with to begin. And that's where it comes to, the wheels come off it. And I appreciate what you've done, and I know that this agreement came about because it was legislation that was defeated. And so when the legislation went down, we found a way to game it and do a settlement that becomes law without everybody being at the table. As I said earlier, if you're not at the table, you're on the menu, and I'm telling you right now that we are being gamed to a point where no wonder the American people are losing faith in the people they have sent to represent them. So I thank you. I yield back, Mr. Chairman, and I thank you for your patience, and thank you for calling this hearing. It is essential that the people of the United States, not the people who are in the Beltway, understand how to game it, but the people of the United States understand that they do have their day in court, and they should have been heard. And when they find out there was an out-of-court settlement made, that just rubs them the wrong way. And you know what? It doesn't pass the smell test.
I would like to thank the witnesses for being here today. This is a very important issue, and this something has to be resolved. One of the things this committee has responsibility for is process. Make sure process is followed. We also have responsibility dealing with the relationship between the states and cities, counties, and the federal government. And it is essential that the states, cities, counties do their responsibility and the federal government does theirs. And you do bring things to light, and I appreciate all opinions coming out and being able to be shared today. And we will continue on a process of this Congress checking into these issues to make sure that we continue to follow through. So thank you, and with that, the committee stands adjourned.